housekeeping. I hope everybody can hear me. Way at the back there. I don't like being distracted when I'm busy in court. So can I ask the media that keeps on moving around that you take your positions and remain in those positions until we're done. No walking around, no roaming, it's not a circus. Then, certain types of devices will affect our recording. I've been told that some of the cell phones affect it, except for the media that's here. Not going to allow people to make videos from the back because it will distract me. That's why I'm also asking the media to be in their positions. I'm going to conclude the judgment, and I want people to remain calm until we adjourn. Often at the end of the judgment, there's still some housekeeping to be done. So please work with us. Everybody's been well disciplined through the course of this trial. Let's keep it that way. The judgment itself, I suspect, won't take that long. As I've indicated, the day before yesterday I wouldn't have had an opportunity to write a full judgment. I have notes. So I'll be going between screens, pieces of paper lying around, and work my way through that way. Now, before I deal with the judgment, I thought it would be appropriate to first express my gratitude to everyone that assisted us in being able to bring justice closer to the people, and that we can serve this community in a proper way, but also in an attempt to bring justice to Joshlin, the missing child. In no particular order, I'm going to name certain persons. Doesn't mean that I don't appreciate everybody's assistance that we had through the course of this trial. It didn't go unnoticed to me that every morning when I arrived at the venue, there were a group of mothers that were praying outside. And I'm sure they weren't the only ones that kept us in their thoughts and in their prayers during the course of a difficult time for all of us. I appreciate that. I visited this venue on the 5th of February this year for the first time. When the matter came into our system, closer to the end of last year, it was decided that I will preside over the trial. And in the exercise of my discretion, I thought it would be appropriate to come here, not particularly the venue, but the area. So you will realize that between the 5th of February and 3rd of March, when this trial resumed, it was less than a month. During that period, we also had to issue a special proclamation to proclaim this venue as a court. And I wish to express my appreciation for then our very new Judge President, Abinda O'Connor, that immediately bought into the idea, supported it, and ensured that we could proclaim this venue as a court before the end of February. And it was done. At that visit, there was still a lot of uncertainty from the local authority whether they would allow us to use the venue for various reasons, but there was no opposition once I've explained the position. And from that day on, we had the full support of the local authority. Everybody would have realized that we're using a sound system, and Mr. Marman over there became known with his trial as Fergus, and Miss Adams next to him. All of this that you see was provided by local government. I noticed the presence of General Patakile above there. But within a week, instructions were given from the provincial office of SANS to support us. And you would have seen that they were here. Within a week, I was told by the staff of the Office of the Chief Justice that an operation plan has already been developed. We all know of the strain the South African Police Service is under in serving the communities. And yes, one doesn't want too much of a show of force in a court setting. But everybody took it seriously, and thank you, Commissioner, to you and your members, Colonel Moody and the team that were here. A lot of sacrifices were made during the course of this trial. Officials had to get up in the early hours of the morning and put in the extra hours and leave their families because they had to go to Malmesbury every day to fetch Mr. Apollos and Mr. Smith to have them here on time. And we started at 8:30 in the morning. I'm sure on those days that we sat late, they got home after dark. I appreciate the assistance. I went through a difficult time with my health during this period, and people need not be too concerned about it. It's merely an underlying condition that's exacerbated by environmental effects. But we had the Provincial Department of Health here, in the EMS that could assist us, that the trial could proceed. At the time when Ms. Smith fell ill, they were at hand. At the time when Ms. Lombard, one of the state witnesses, fell ill, they were here. Our own internal office, which represents the Office of the Chief Justice, through the provincial head, acting head, Ms. David, and particularly Mr. Roscoe Vessel, who was our acting court manager at the time, pulled out all the stops. Witness dog had to be procured from another government department, the Department of Justice, the National Department. We attempted to procure an accused dog. I just had to pick up the phone to ask SAPS to assist us to transport it, and unfortunately it was too small when we got here. It might sound small things, but what it taught me of how local government, provincial government, national departments work together in ensuring that we achieve the ideals of restoring human dignity in our Constitution. I hope this was a good example of what we as people can achieve if we work together. The community of Saldanha came up at times in numbers. I have in quite a long career seldom seen people so disciplined. On the first day or two, Mr. Marman indicated to me that people were leaving their paper wrappers in the courtroom. It placed a strain on the cleaning staff. I addressed the court goers. We never had a problem again. The behavior of people in the court and the way they rallied behind us to support us in what we do showed of a community that cares. I'm going to say a little bit more about that in the judgment proper. I appreciated when I made requests to Mr. Apollos, Mr. Van Reynen and Ms. Smith to bite the bullet and not have their lunch or have a shortened lunch, realizing that they are in custody. They cooperated fully. And you will realize that I'm coming from the back and coming closer to the bench. We needed assistance of admin stuff to be done, and you could see the investigating team running around making copies, etc. I put a lot of strain on counsel for both the state and the defense. But similarly, you have made it much easier for me because of the manner and the professional manner you performing your function, prosecuting the case on the one hand, and defending your clients to the best of your ability on the other side. Last but not least, and I apologize if I've left out anybody in this process, our own staff, my own staff. You will recall that not all of council had sent me the authorities, and sometimes the references were wrong. But when it popped up on my screen, it was the correct case. It was work done behind the scenes. It was not the job of Ms. Naidu Chetty and Ms. Pulani Mkwena and Sylvie Cobb. And at the time, it was the Yankees and Mr. Blau was here as well. On Tuesday evening, rather Wednesday morning at 19 minutes past 3, we received documents. It wasn't sent to me directly, it had to go through the conduit. It reached me before I woke up. Council was assisted with all sorts of issues. If I didn't have the assistance yesterday of all three of them, working with me at my accommodation on Workers' Day, typing, pulling out exhibits, because I was dictating my thoughts whilst cooking, and either one of them had to go to my exhibit file and take out papers so that I can reference them. That's going the extra mile, but it shows the commitment, and I appreciate that. Now those are the pleasantries that are not part of the judgment. Now, as I've mentioned in the remarks I've made before I start this judgment, although it is a criminal case where the purpose of the hearing is to determine the guilt or the innocence of persons accused of criminal conduct. This case primarily deals with Joshlin, a young child that went missing and is still missing. Now, there's a popular saying which often is overused, and it says that it takes a village to raise a child. It implies, among other meanings, that an individual is not an island, that a person is a person through other persons who belong to, and that, perhaps most importantly, that a child must be protected by those around it in order to truly thrive in society. It has other implications too, if we take it seriously. For a village to raise a child, that village village must be healthy, and the material conditions of that village must be such that the child can flourish. I remind ourselves that we're dealing here with the life of a child. In this matter, it takes in a certain point in time. Here we have a village where a child was not safe. This is not necessarily because of the community in which she was born and lived, as we can freely see through the public interest in the case, but because of multiple factors, including the material conditions of the community in which Joshlin was raised. A village does not exist in a vacuum, and nor is a child raised in a village alone. It is and remains the responsibility of the state, and in particular, taking it from myself, the judicial system, to ensure that children are protected. It becomes our responsibility that every child that grows up in our village, in which it was protected to live as a citizen in society, that defends that protection. It is our role to ensure that all are protected, so that every child that is raised in our village can turn into an active, contributing member of society. And it's for one of these reasons that the act for which the three individuals are charged were enacted, I turn my attention to the preamble to the Prevention and Combating of Trafficking Persons Act, number 7 of 2013. And it reads, to give effect to the Republic's obligations concerning the trafficking of persons in terms of international agreements, to provide for an offence of trafficking in persons and other offences associated with trafficking in persons, to provide for penalties that may be imposed in respect of the offences, to provide for measures to protect and assist victims of trafficking in persons, to provide for coordinated implementation, application and administration of the Act, and to prevent and combat the trafficking in persons within or across the borders of the Republic, and to provide for matters connected therewith. Section 41(1)(b) of this Act provides for the establishment of an integrated information system to facilitate the effective monitoring and implementation of the Act, and to recommend interventions relating to trafficking in persons by collating and analyzing the information obtained in terms of sections 25, 4C, 39, 44, 1D, 44, 5C, 44, 7C, with a view to determining, amongst others, the establishment of integrated information systems, and so forth. The Act further provides for strict application. Therefore, the development of the monitoring systems. I may have done a cursory research, but I couldn't find a system that was accessible and operational in the implementation of the Act. Maybe it's time that something is done, as this is not an isolated case. Could be, as Ms. Swanepoel on behalf of the state argued, it's the first of its kind, but maybe we don't know, because it's not properly recorded, in order for us to be able to combat it effectively. Turning to the individuals before the court and the charges they face, Mr. Apollos was at the time of the charge 31 years old. Mr. Van Rijn was 27 and Ms. Smith was 33. I noted the other day when I signed the warrant of detention, postponing the matter to today, that it was a birthday yesterday, on the 1st of May. That's also, I was reminded of that when I looked at the evidence of Ms. Michaela Daniels in the manner in which the date of birth was reflected. So if at the rest was 33, should have been 35 yesterday. I mentioned the ages of the three individuals as it relates to the charge itself as well. They are charged with different offences and alternatives which I do not deem necessary to read the whole indictment for today's proceedings. And it is that between the 18th and 19th of February 2024, in the Judicial area in Malopos, that Joshlin Smith was 6 years old at the time, born on the 23rd of October 2017, was trafficked. Therefore, the charges are brought under Section 4(1), 10(1)(b), read with 4(1), 10(1)(c), read with 4(1) in the Act. So it's a main and the alternate charges, and there was a second charge of kidnapping. Now, in the main and alternate charges, 3 And I will turn to the question whether the means is in fact a necessary element when the victim is a child. But generally, the state needs to prove what was done, as the provisions of the Act is that any person who delivers, recruits, transports, transfers, harbors, sells, exchanges, leases, or receives another person. How? The means. And it then gives you a number of alternates, which would include kidnapping, the abuse of power, the direct or indirect giving or receiving of payments, and alike. And then the purpose, why it is done. It is clear that, therefore, that the state must prove beyond a reasonable doubt that an accused person committed any one of the listed acts, as set out in the indictment, by using any one of the listed means with a purpose or with an exploitative purpose. Now, it was argued on behalf of the state that international law does not require that in the event where the victim is a child, the means must be proven. And they relied specifically with reference to section 11.1 of the Act. In this regard, on the unreported decision in State versus Leggy Wellington, Asana, and two others. It's an unreported case from the Eastern Cape High Court sitting in Calais, under case number CC 16/2018 ECG. Judgment was delivered on the 14th of June 2022. I pause to note that unfortunately it seems that some of the judgments in the Eastern Cape didn't find its way into safety. I actually took it up as on a call with my colleagues in the Eastern Cape yesterday to alert them to it. This judgment was delivered by Joshlin Kidnaping, as his name was. And it dealt specifically with the charge under section 4.1 as we are dealing with here. And the judge gave a full analysis of the law as well as the academic articles, and referenced the international instruments. He came to the conclusion that where a victim is a child, it is not necessary to establish that one or more of the sections of the Act was complied with. For purposes of the judgment here, this is an extempore judgment. There's no need to explain further because it's clearly set out in Masala by Joshlin. However, it's important that for the reasons set out there, I'm in full agreement with the exposition of the law and the conclusion reached by the court in Masala. And insofar as it relates to this case, it is the to that extent means that there is a difference in the elements to be proven by the state where the victim is a child. It will become apparent later why I find it necessary to draw that distinction. Now, in an attempt to discharge the onus that rests on the state, they call 35 witnesses, handed in 42 documentary exhibits, 5 physical exhibits. We attended to an inspection in Logo, and this trial so far lasted us 35 days. I did not count the hours, but it was many. There was no evidence presented on behalf of the defense. The effect thereof was that the majority of the evidence either became common cause or it stands undisputed before the court. I am conscious of the fact that insofar as it relates to certain witnesses, that I need to evaluate the credibility and reliability of those witnesses carefully. And I shall return to those witnesses in particular later. I have decided to state the facts which are common cause and all undisputed before the court, not as is customarily done in a summary trial, where one summarizes the evidence fully, but rather to integrate the evidence of the different witnesses in a timeline from which I shall then draw conclusions and inferences at the end of the judgment. So I decided to start much earlier on my timeline from what the state suggested in the evidence that was produced before me. From the evidence of Ms. Celise Brown, who is employed as a social worker in the Department of Social Development, Ms. Smith became known to the department as a person in need of support as far back as 2016. She was the adopted child of her grandmother, and from the file contents, as Ms. Mbambo was not in the employ of the department at the time, a predecessor recorded the information. Ms. Smith had an addiction problem that caused further tension in the relationship with her grandmother. As I've indicated, Ms. Mbambo doesn't have personal knowledge of the information, and strictly speaking, that evidence is hearsay. It's however not challenged. firstly, and there's no prejudice to Ms. Smith in admitting the evidence. Therefore, the evidence would be admissible in terms of the evidence amendment law as hearsay evidence that is admissible. That was 2016. During 2017, the grandmother again reported to the department, stating that Ms. Smith had another child. That child was Joshlin. The older son was in the care of the grandmother, for whom she received a social grant. But she couldn't provide the whereabouts of Ms. Smith, although reporting that she recently had a child, but they didn't know where she was. On the 20th of March, the next year, 2018, so Joshlin would have been approximately 5 months old. Ms. Smith attended to the offices of the department to seek assistance, as she was allegedly in an abusive relationship and needed help. Also for her own substance addiction. By then, Joshlin's birth had not been registered. Ms. Smith was then assisted by the social workers to register Joshlin's birth and to assist Ms. Smith to be committed to a rehabilitation center. That's the first time we also hear the name Natasha Andrews. Because when Ms. Smith had to be committed, Joshlin was placed in the care of Natasha Andrews and her family. We heard the evidence of Ms. Andrews that they attempted to adopt Joshlin during 2018, but the parents were uncooperative. She didn't give us the date, specific date. She mentioned the year. That's confirmed by what had happened in 2018 with Ms. Smith and Joshlin. It is important to note the relationship between Ms. Andrews, Ms. Smith and Joshlin, as that relationship between Ms. Smith and Ms. Andrews will become relevant later. However, although they didn't adopt Joshlin during school holidays and often over weekends, although Joshlin was staying with her mother, she would often spend time with the Andrews family. During 2023, just now a few years later, Joshlin was then in grade R. Then it became school holidays. In other words, long periods to be spent with the Andrews family. Regular contact would would be between Miss Smith and Miss Andrews. Fast forward to a cold morning in August of 2023. The temperature this morning was 5 degrees when I was driving in. Mr. Joshlin Kidnaping was on his way to work. He hails from the Makoland, so does Miss Smith. He does general work at people's homes and is also an evangelist in the Christian faith. 2016 roundabout, he attended a memorial service at a funeral. That's where he met Miss Smith. Realizing that they were from the same area, they exchanged pleasantries. And although they didn't see each other regularly between then and 2023, when they would see each other, they were friendly. According to Mr. Kidnaping, they could have been regarded as friends. And he referred to her, and she in turn, as his homie. During the process, she requested him to see whether he could procure a position for her, doing domestic work with some of the people where he performed these tasks. On this morning that I spoke about, he was surprised to encounter her that time of the morning, as his initial impression was it was somebody jogging. She seemed upset and lamented about her unhappy family life. He wanted to know where she was coming from. And where she was going. He was unaware at the time where she resided. She pointed over her shoulder to a blue house and said she lived just behind that house. And she was on her way to do a cleaning job. She left the children with Buddha, Mr. Apollos. Because of this bad family situation she was in, she was going to have the children removed. Turned out later that reference was made to a child. The statement of Mr. Kidnaping was handed in to evidence where it became apparent. But it's neither here nor there in the bigger scheme of things. When he then inquired where to and to whom, she did not reply, but said she was waiting for people that were supposed to come, but they disappointed her. But in the event that they would now turn up, she would be prepared to accept less than the 20,000 rand and would be satisfied with 5,000 rand. She gesticulated with her hands and told him that in the next year, January or February, he will see what will happen in Middelbos and Tierdsville. It will look like a movie scene with cars and people. They will search but not find. These were his exact words. She will let the child go far. He remembered her clothes, as it was unusual for the weather conditions at the time. He saw her again during the September school holidays of 2023, where he saw Joshlin, and he described her eyes as the most beautiful that he had seen. It sounds better in the Namakwaland way of expressing, as Mr. Kutsia did. Miss Laurentia Lombard, whose evidence I will deal with in detail later on, lives a stone's throw away from Miss Smith and Mr. Potts. They were friends who shared a lot, but they were also drug buddies. They would see each other on a daily basis, using drugs. From the available evidence, Ms. Smith seems to have been the provider of the financial means and often supported Ms. Lombard with food for the children, for her children, Ms. Lombard's children. Ms. Lombard had four children, of which two was living with her, and a partner, a younger. On Sunday, the 18th of February 2024, the Apollos and Smith residence was visited by a detective inquiring about the loss of chickens on a nearby farm. The complainant in the chicken theft case was identified, and Ms. Smith's response was that she couldn't believe that this complainant would point fingers at Mr. Apollos, and that she would now take revenge by informing the complainant's wife of his infidelity. Stronger words were used. This led to a heated argument between Mr. Apollos and Ms. Smith that later on escalated to Ms. Smith breaking a window and threatening to stab Mr. Apollos. After the breaking of the window, Ms. Smith and Mr. Apollos were inside the house, where Ms. Lombard could overhear a discussion between the two of them. They were talking about Joshlin. It's instructive to note that Mr. Apollos, in his statement that was admitted in the trial within a trial that was made to Colonel Pretorius, confirms a discussion in the vein as described by Ms. Lombard. And in a separate interview with Captain Lombard with 1A, Mr. Apollos confirmed the argument and also confirmed that both of the children were there. Miss Paulina Chaucer, not knowing any of the dramatis personae, was on her way to have her hair done in the late afternoon, early evening, as the time is not, she's not certain of the time. On that Sunday, the 18th of February 2024. The route to the salon would take her past the rocks close to the house of Mr. Thomas and Miss Smith. She describes this argument and that Miss Smith dragged Joshlin towards the house and uttered the words, "Exhale your waste." I pause to note it's unclear whether these words were directed at Joshlin or Mr. Apollos, having regard to the genesis of the argument. It was heated, according to Miss Chaucer. She also recognizes Miss Lombard, or describes somebody that resembles Miss Lombard. It's also an aspect I will come back to later. According to Miss Lombard, Miss Smith then took Joshlin to a white polo vehicle and to a woman whom it would seem to be traditional dress. She had distinctive white spots on her face. She describes this person as a Sangoma due to the appearance. She saw Miss Smith receive something that she had placed in her pants, whereafter she returned to her house with Joshlin. She then tells us that she overheard Miss Smith telling Mr. Apollos that she received 20,000 rand. Miss Lombard then approached Miss Smith whilst Mr. van Rijn was present, and upon inquiry, Miss Smith stated that she had sold her child Joshlin and had done something bad. Again, strong words were used. But for her silence, Miss Lombard will receive 1,000 rand and Mr. van Rijn 1,200 rand. According to her, both she and Mr. van Rijn accepted the offer. The next morning, earlier than usual, that was Monday the 19th of February 2024, Miss Lombard went around to the Smith residence, where she found Mr. Apollos, Mr. van Rijn, Miss Smith, and the 3 children of Miss Smith. According to her, Miss Smith would have given instructions of how the handover of Joshlin will take place around 2 o'clock the afternoon. Thereafter, Miss Smith left with the youngest of the 3 children. Both Joshlin and her older brother did not attend school that day. The reason for this non-attendance, given to different persons at different times, changed between unwell and dirty school clothes. Turning back to Miss Smith, She was working for Miss Carlin Seegers and her daughter Kelly, performing general housework. On that morning, according to Miss Carlin Seegers, Miss Smith arrived extraordinarily early. She received the keys to Kelly Seegers' house. Whether she went to work or not at Kelly Seegers' house became unclear at the later stage because Kelly Seegers has a camera, CCTV, and no footage of Miss Smith can be found for the 19th of February on the recording. On the other side, in Middelbos, Joshlin was still at home, where Miss Lombard, Mr. Apollos, Mr. Van Rijn were present. According to Miss Lombard, she exchanged a bag of hers for a quarter mandrax heroin, which was consumed by the 3 adults present. Cross-examination. It was disputed as to who partook in this consumption, but both Mr. Apollos and Mr. Van Rijn, in the statements they made to Colonel Pretorius and Captain Seerquist, confirmed that consumption. Turning back to the events of the 19th, at some stage before 2 o'clock in the afternoon, Miss Smith was back at Colin Seegers' house, where she borrowed 50 rand and made her way home. Miss Lombard narrates that it was then that Miss Smith took Joshlin to the car, the same white polo from the previous day. Mr. Apollos, Mr. Van Rijn, and Nilo was present. According to Colin Seegers, Miss Smith was away for approximately a half to 3/4 of an hour. Miss Smith then returned back to her house in Middelbos, round about 5 o'clock, where after she, Mr. Apollos and Mr. Van Rijn took a gas canister to be filled. They bought some, took and smoked it. Mr. Apollos and Mr. Van Rijn had to collect money from items sold earlier, which included a microwave. It is interesting to note that Miss Lombard also refers to this. Joshlin was not home. Nobody is searching for Joshlin at that time. Miss Smith shows no concern. Mr. Apollos shows no concern. Mr. Apollos and Mr. Van Rijn later departed to Telmaki Street to go do their drugging thing for the rest of the evening. Exactly what time Miss Smith showed any interest in finding Joshlin is unclear. However, at approximately 8:20 that evening, she and another person, who could have been Namshla and Tinsley, attended at the residence of Miss Andrews. According to Miss Andrews, Miss Smith inquired whether Joshlin was with her. When asked about Miss Smith's demeanor, she said she did not seem anxious to her. This was an opinion expressed by the witness. I have indicated above the long relationship and close relationship between Miss Smith and Miss Andrews. Miss Timsey and Miss Smith were searching at one stage, and at one stage they attended to a residence in Peter Mukaba Street, which was a place identified where Joshlin could have been. Miss Timsey's concern was that Miss Smith spent an inordinate long time inside the house, and that the search was not continuing. Upon inquiry from her as to what the reason for the delay was, she was told that Miss Smith was charging her phone. It was thereupon that Miss Timsey insisted they inform the police. This is now approximately 9:30 in the evening. The complaint was attended by Sergeant Kobese and Constable Gongoda. They inquired at both the Zeekers residences, and as Miss Smith did not have a photograph of Joshlin, they collected same from Miss Andrews. After all the administrative work was done, and Mr. O'Pol was eventually found in Talmaki Street, a statement was obtained for a missing persons report from Miss Smith. This was Exhibit QQ. What stood out in that statement was that Joshlin did not go to school because she was, I quote, not feeling well. When she returned approximately 13:50, according to the statement, Mr. Apollos was not at home, and then there's some vagueness in the statement as to whether she was asking about the whereabouts of Joshlin or not, and whether the father was looking for the child, referring to Mr. Apollos. But in the same statement, hence my confusion, it's also stated the father last saw the child at about 1300 hours, 1 o'clock. No mention is made of Mr. Van Rijn. After all the work was done by the police, Mr. Apollos and Miss Smith went to sleep and were searching for the night. According to Miss Andrews, she saw Miss Smith early the next morning, and again she did not look anxious. Now the police were mobilizing upon the missing persons report. Detective Molstein and Detective Sergeant Lefiwe Segobe were on duty somewhere in the Swartland when they were called back to Saldanha. Detective Sergeant Molstein took a statement from Mr. Apollos. 3 things stood out. He said, Joshlin had a cold, makes no mention of Mr. Van Rijn, but at about 11 o'clock, he washed the children's clothes. Both of the children were home, as well as himself, when Miss Smith returned at lunchtime, where she remained approximately 20 minutes. Detective Sergeant Corroboration went around to Miss Lombard. This statement brought a new issue to light: the presence of Mr. Van Rijn. The same morning, on the 20th of February, the class teacher, Miss Edna Maart, made contact with Miss Smith, and although she asked her twice about the absence of Joshlin at school the previous day, she received no answer. What also became apparent at the time, over and above a comment made by Ms. Smith to Lieutenant Colonel Sabola, the station commissioner, about a child making her famous, neither Ms. Smith, Ms. Lombard, Mr. Apollos, or Mr. Van Rijn participated in the search. Although many, and I stress many, police officials, community members, people from afar were searching day and night. But let's get back to the day of the 20th, because that night Miss Smith slept at the home of Kelly Zegers, and she gave an interview. Her concern was that this is not Kelly's concern. Kelly Zegers is concerned, because Miss Smith is also known as Kelly, was that Miss Smith showed no emotion and did not appear to be concerned about the missing child. She slept like a baby, whilst Miss Zegers couldn't. In the interview, the moment suggestions were made that Mr. Apollos could have been involved, she became aggressive. Now, on the 23rd of February, this is now a few days later, Ms. Smith encountered at least two persons who testified in court. I returned to Ms. Celise Van Bambo, the social worker, because at the request of her manager, she had now become involved. And that was her first involvement with Miss Smith, to see what assistance they could give to Miss Smith, because she had a child that was missing. Miss Smith told the social worker that Joshlin did not go to school because her clothes were dirty, and that she did not have any soap. A pause. Previous and in a later statement Ms. Smith made, she says she went home at 10 to 2. Where did the soap come from that Mr. Apollos used at 11 o'clock? Whilst I'm at the evidence of Miss Bambo, she told us about the attempt she made to get Miss Smith into a safe place, but Miss Smith was uncooperative. On that same day, the teachers participated in a search, and Miss Mark was at the filling station, where suddenly Miss Smith appeared in the vehicle. It was then that she had told Miss Mark about this call she had from a seer that her child was on a ship on the way to West Africa. Then, before she alighted the vehicle, in a low tone, she said to Miss Mark, she must just remember that Buddha, Mr. Apollos, is innocent. Now, it would have been apparent from my summary so far that there were discrepancies in the reports that was now with the missing persons inquiry. From the 20th through to that Sunday, the 25th, Captain Lombard with 1A, I draw the distinction because Miss Lombard has 2 A's in her surname. Who is attached to the Provincial Organized Crime Kidnapping Task Team, who also then became the investigating officer at the later stage, or the lead investigator at the later stage. He had contact with Sergeant Milstein after difficulty in the beginning, getting a hold of him, because Sergeant Milstein's telephone must have been overloaded with calls and so on. And offered his support to the team that was leading the missing persons investigation. Because, as the title of the unit is, they specialize in kidnapping cases and come from the high onto the stations. And during that period, Sergeant Milstein had relayed to him his concern about these prima facie discrepancies. He then decided, or it was then decided, that he should travel down to this area to interview Miss Smith and Mr. Apollos. That first trip then happened on Sunday, the 25th of February. At the time, when interviewing Mr. Apollos and Miss Smith, he was aware of the contents of the statements, the interactions with the missing persons team, as well as concerns about their demeanor and their conduct in general. This raised red flags for him. Mr. Apollos confirmed in that interview that the 2 children, this is Joshlin and my older brother, did not attend school because they were sick. And what he found strange was when he inquired from Mr. Apollos about his relationship with Joshlin, Mr. Apollos became evasive and referred the answer to that question to Miss Smith, who was outside at the time. He also confirmed that Miss Smith returned home during the course of the day to Smithton. And although he couldn't give an explanation as to when and how Joshlin disappeared, he stated that both him and Mr. Van Ryn took turns in watching Joshlin. Mr. Apollos also confirmed that he did not partake in the search. And he confirmed the presence of Ms. Lombard on that day. Ms. Smith appeared irritated and confirmed that Joshlin was left with Mr. Apollos and the smoking of it. Captain Lombard was surprised by a response to a question when Ms. Smith said, and I quote in Afrikaans, "Meneer, my kind is nie meer in Saldanha nie. Ek moet aangaan met my lewe. Ek het nog 2 kinders. Sir, my child is no longer in Saldanha. I must go on with my life. I have 2 other children." When he wanted to know, but how does she know that Joshlin is no longer in Saldanha, she responded, "Her child is gone. My kind is back." According to him, she was emotionless and cold, not being involved in the investigation before the attempts for clarifying issues. Then he wanted to take a supplementary statement from her, supplementing the statement that was made on the night of the 19th, early hours of the morning of the 20th, to Kobesi and Gogota. Her response was even more surprising. She had no time to give another statement because she had to go to the spur with Mr. Apollos. This didn't surprise him. Well, this was not the only surprising issue. As what he found strange, here we have a mother, but she's not asking for an update on the investigation or what new information is available, but rather she said that Joshlin made a focus. Michaela Daniels is a sister of Miss Smith. She happens to be a police official in the Northern Cape. The 2 of them spoke on the 26th of February 2024. So this is the day after Captain Lombard's interview, where the responses were given as I described above. Miss Smith informed her sister that Joshlin was still in the area and that someone wanted to sell her child and that she is in the informal settlement. But it is too heated in Saldanha at the time. When she wanted to inquire further, Ms. Smith's response was that she knows Miss Daniels is a police official, and she's now asking her the same questions the police have already asked, so she's not going to answer. On the question as to why did Joshlin not attend school on the 19th of February, she was told that Joshlin's school uniform was dirty and that Miss Smith did not have the money for washing powder. I've already referred to the 11 o'clock issue in Mr. Apollos' first statement. On the 22nd of February, before this interview, attempts were made to obtain a statement from Mr. Van Ryn, because one might find it strange as to why Mr. Lombard, or Captain Lombard, only spoke to Mr. Apollos and Mr. Smith, because there was not yet a statement of Mr. Van Ryn. The response from Miss Smith to Miss Daniels about the sale of Joshlin becomes apparent and important because of what happened on the 22nd of February at the residence of Mr. Van Ryn. When Sergeant Molstein arrived there, Mr. Van Ryn spoke to members of the community, and in that conversation he already speculated about the sale of Joshlin. Sergeant Molstein, however, did not take a statement from Mr. Van Ryn on the day, because his impression was that Mr. Van Ryn was under the influence of drugs and he didn't want to take it further there. However, Mr. Van Ryn did make a statement, and that was on the 29th of February to Detective Sergeant Philwe Segobe, denied any responsibility for what happened on the 19th. On the 2nd of March 2024, the then Minister of Police visited the area. But importantly, on that morning, Captain Lombard encountered Miss Smith at the police station. She was well dressed in a dark green dress and clearly had hairdo. After some comments made by Captain Lombard as to how well she looked, she responded that Joshlin made her famous. I referred to the same sight and the same words to Lieutenant Colonel Sebola. This comment also found its way to Ms. Hanif, the so-called TikTok influencer. I'm just going to pause for a moment. I can see there's some activity going on. So when I return, I'm going to take a bathroom break. Some people want a bathroom break. When I return, I will continue on the events of the 3rd of March, because that led me to Ms. Khandif at the video. It's now 11:31. How long do you need? 10 minutes? 10 minutes, okay. Let's make it 11:45 rather. It's 11:32 now, it's a 13-minute break. 11:45 when I will return. Court will adjourn. after the visit of the then Minister was the 3rd of March 2024. A prayer event was held here in Saldanha. Ms. Hanif, that I referred to before the break, bought clothes for Ms. Smith. A boy band by the name of the Temple Boys was arranged by a politician who performed at the event. Ms. Hanif took a video that was handed in, where Ms. Smith was happily dancing away in a jovial mood. Importantly, Mr. Nico Kutsia was also present at the event. At one stage, Ms. Smith was called onto the stage to receive the blessings, and he recognized her as his homie, whose child is now missing. And he remembered what she told him in August the previous year. He was bothered by this and attempted to inform his wife thereof. She, however, retorted that they were simple people. This is too big for them. They shouldn't get involved. With due respect to his spouse, he took time to reflect upon it. It, however, bothered him so much that he was looking for the first opportunity to share what he knew. The following Wednesday, unaware of the events that took place between the 4th and the 5th of March, that Wednesday was now the 6th, was the first day he was working in Jacobsbaai for the Krugers. I also paused to note that he also worked for a person by the name of Jacques Louis van Sail, who is the neighbor but for an open plot to the Krugers. He happens to be the control prosecutor at Vredenburg. So on the morning of the 6th, reporting the issue to the Krugers first, who then called Mr. van Sail. Mr. van Sail was already aware of the events of the previous day, and that Ms. Smith was implicated in the offences. Whilst we, at the event of the 3rd, and reflecting on Ms. Hanif and the dancing of Ms. Smith, let us return to the 20th of February, when she was in a video call with Ms. Smith being at Kelly Seeger's residence. I referred to the irritation shown by Ms. Smith earlier on upon the inquiries about Mr. Apollos. But at that stage, Ms. Smith also told Ms. Hanif that the police must do their work and they must stop looking for Joshlin. The terminology used at the time to Ms. Hanif was not referring to Joshlin by her name, but rather as the child. I mention it here as the next topic I shall deal with is the admission of the statements by Mr. Apollos and Mr. van Rijn. Because what became apparent in those interviews, that Joshlin was not called by a name, but rather Dickent, the child. So let's revisit the trial within a trial. And I shall not dwell on it for a long time. And the reason for that will become obvious. Day after the visit by the minister and the prayer meeting was a massive search in this area, where this venue that I didn't know of before we chose the venue became an operation center. Police officials from all over the province, of all detective branches and all the different sections of SAPS, community members, community organizations, interested people were searching the broader area of Saldanha Bay towards Jacobs Bay, the dunes, the beaches, the Navy was involved, and it became a big operation center. What nobody knew was that Captain Lombard and his team was in the field that day, but led by their commanding officer, Brigadier Nana, who took up position at the sea border offices, sitting in the FCS commander's office. They have already decided that they will have to now re-interview the three individuals, being Mr. Apollos, Mr. Van Lane, and Ms. Smith, on the same basis of all these discrepancies and the red flags that were raised earlier on that I've discussed, plus the conduct of the individuals in the meantime. So after concluding their work on the search, Mr. Apollos, Mr. Van Rijn, and Ms. Smith was brought in by different people to the offices of Sea Border Police, where FCS offices are also situated. Interviews were conducted, and various police officers testified as to what had happened, but more particularly Captain Lombard, Sergeant Fontaine, Sergeant Johnston, as it was alleged that undue influence was exerted on Mr. Apollos and Mr. Van Rijn, and they were viciously tortured. Some demonstrations became laughable, to say the least. The indications on the evidence and what was put to the witnesses were totally different. Plus, I was told that what they had admitted to in those statements came from the police, and the police told them what to say. I have no hesitation in finding that the evidence for the defense on that score was so bad that nobody can believe it. No wonder they didn't come and testify again, because the prosecutors wiped the floor with their evidence, to use the colloquial term. On the other hand, there was no reason not to accept the police evidence of the officials that I've mentioned, because over and above the medical examinations and what was told to the doctors by Mr. Apollos and Mr. Van Ryn as to how they sustained certain injuries they had on their body. I was fortunate that a process was followed where these statements were video recorded. It then not only sits with somebody to add on because you can see what's in front of you. One can see the demeanor of the deponent. One can see the conduct of the police official taking the statement. One can see the scene. It doesn't end there. Let me turn to Mr. Apollos briefly. We took time, sentence by sentence, confirming or not confirming, both by counsel on behalf of Mr. Apollos and myself. And then, of course, as we know, what's confirmed when Ms. Smith is not in the courtroom is recanted when she is. To make it worse, I've been told that what's in those statements came from the knowledge of the police. But then Mr. Apollos tells me he made up the story as he was sitting in front of Colonel Pretorius, which prompted me to pose the question where his sudden talents came from. Because there was information in those statements that the police had no knowledge of. Similarly, with Mr. Van Ryn, turned out that, and I've criticized Captain Seekwe about it, that not everything that he said was written down verbatim. If one listened to the audio on the video, on the recording, it's crystal clear what he said. And a lot of those issues were not challenged. It was claimed that he was asleep, or that when he yawned, his brain was malfunctioning. But when he testified, it was a different story. Then he was wide awake. Initially, he was spun like a top around an axle. Then, when it became apparent that it is impossible, then he was just swinging or rocking like a boat. We asked him to illustrate. It was clearly impossible. Initially, it was unclear what type of pole or pipe or structure was used to spin him around. Then it became a crutch. Not knowing there was a gentleman in court that had a crutch. the least said about it, the better. My finding is that the credibility was so bad, and on the other hand, the state's evidence was of such a nature that I found it to be credible and reliable, and the statements were admitted. Mr. Apollos and Mr. Van Ryn made their statements, but before they departed, that evening or early morning of the 5th now, there was the encounter between Mr. Apollos and Miss Smith. Miss Smith did not give a statement then. She gave a statement at a later stage. That became the warning statement. Both of them at some stage told the police they must ask Miss Smith. When she was told that they said that, she exploded, asking Mr. Apollos how he could do that to her because she loves him. I'm going to deal in a little bit more detail with Mr. Coetzee and Ms. Lombard. But before I turn to them, it's important that one have regard to the so-called warning statement of Ms. Smith, which was handed in as Exhibit QQ. And this is a statement that she wrote in her own hand. If you look at the time that was given there, she returned home at 11:30. She borrowed the money, bought tik, went home, and she was back at Carl and Ziegers' house at 12:30. Then she eventually went home at 16:45, 4:45. Joshlin was not at home. Now contrast that to the previous statement that I've mentioned. The time that she realized that Joshlin was not at home, the latest would have been 5 o'clock. Thereafter, both herself, Mr. Apollos and Mr. Van Ryn, went on their sojourns to get the gas and to go and dump. No concern. That's on the version, insofar as it's a version of Ms. Smith. Now let me turn to Mr. Coetzee first. Mr. Coetzee is a single witness as to what had transpired on the August morning of 2023. Ms. Lombard is also a single witness insofar as it relates to what she describes with the white polo. And I'm well aware that the version provided by Mr. Apollos and Mr. Van Ryn as to how Joshlin was delivered differs from hers. So in both their cases, I will have to apply a cautionary law. I have to find some warranty of reliability for their evidence. When a court considers that, you may also take into account the demeanor of the witness. Mr. Coetzee made a favorable impression in the manner in which he presented his evidence. He has no motive to put himself in this situation and get into the case. At the time when he reported to the Krugers at Van Zyl, he was unaware of the arrest. Where does he get the 20,000 rand from? Because he was never part of any of these other discussions, and it was not out in the public domain either. So, even on the probabilities, would favor his evidence. More importantly, there is nothing to gainsay Mr. Coetzee from the defense. And I shall get to in which instances inferences can be drawn from the silence of a person accused. In this instance, it calls out for an answer, because either he's not only an evangelist but also a prophet, to have known what was going to happen. He says Miss Smith told him that. It's not challenged. In cross-examination is challenged with no other evidence. But it's also supported by the circumstantial evidence around this case. This Lombardy is a bit different, because not only is he a single witness on the commission of the crime as she describes it, but she's also a participant. So I've got to treat her as a single witness, it's a cautionary rule. Got to deal with her as a participant. I also have to have regard that she gave different versions as time went on. When Constable Sikhobe, she was a constable at the time, spoke to her on the 20th, she gave one version. Then she made a statement to Captain Silier, a so-called confession, on the 15th of March. Yes, she implicated herself, but that was not the full disclosure. Then she appears in court as an accused. She's legally represented. In that time, the legal representative also represents Mr. Apollos. She wants to come clean. He withdraws. They appoint a new legal representative for her. Advocate van Tonder, whereafter the discussion takes place. A statement is then prepared after various to and fro and consultations, checked with her legal representative, and that becomes a so-called 204 statement. Further disclosure. So there are those three different statements. Whether they're different versions, that's another issue. Then she comes in court, and she has a difficult time. So from the outset, she was not the perfect witness. But does it mean that if she was dishonest at a particular stage, that I should disregard everything she's saying? Because it is trite. The fact that you pronounce a falsity on one aspect doesn't mean that the totality of what you say is false. The test is that one must look at credibility, but also reliability. And where I apply the cautionary rule, there's no hard and fast rule. It becomes a common sense approach. And I said at the outset, I'm not going to quote all the authorities. I was referred to them, I've taken them into account. It's my understanding of how I need to approach it, and I will do that. So the way it should be done, to my mind, is to see whether there are independent corroboration for aspects in her evidence, if not the totality, where I can find that warranty of reliability. I have asked the prosecutors, when they had to prepare the heads of argument, to give me a mind map. Now let me pause to say, when I deal with her evidence and the mind map, it will also answer my decision, particularly insofar as it relates to Ms. Smith on the application for a discharge. Because Mr. Van Ryn's application was stillborn. As just before that, I had admitted his statement, where he implicated himself with admissions. So I will not deal with the reasons for the 174 separate. Let us go there. So in argument, we went through points that I've indicated I was going to draw lines. of February. That's the talking at the house. There she's corroborated by Mr. Apollos in his statement. So that's the plan. Insofar as the amount of money is concerned, she's corroborated by Mr. Apollos and Mr. Van Ryn. Also corroborated by Mr. Kutsia. As to the argument that ensued on that day, confirmed by Mr. Apollos to Captain Lombard and Ms. Sosa, places her right there. Then, on what happened on the 19th and her presence there, both Mr. Apollos and Mr. Van Ryn, the microwave, and so on. Even that, they had to go and collect the money later. The fact that they smoked a quart of mandrax in the evidence of Captain Colonel Morris, Mr. Van Ryn confirms it in a social media video that was made. The visit to her house on the night of the 19th, where Ayanda got upset. This is confirmed by Gongota and Kobese, totally separate from her. She made mention of that Joshlin was sold. Ms. Smith, she says, spoke to her on the 23rd. No counter evidence to that. This whole issue of hers talking about the Sangoma, Mr. Van Ryn was the one that came up with that at another stage. I can point at a number of issues, and it's not exhaustive, because my view is to look at it differently. We refer to the elements of what the state need to prove on the human trafficking charge, the difference between Ms. Lombard and Mr. Van Ryn and Mr. Apollos relate to the means. She confirms they corroborate her on the plan. At least Mr. Apollos corroborated her on the plan. But both Mr. Apollos and Van Ryn speaks about the execution of the plan of disposing of Joshlin like a commodity on the 19th. And that was the plan on the 18th, according to her. And we know as a matter of fact that Joshlin went missing. Read all of that in, and then I'm going to turn to all the circumstantial evidence and the conduct of the parties and the fact that no evidence was placed before the court for the defense. So when one analyzes the evidence of Ms. Lombard that was available at the end of the state's case, no credibility findings have been made yet. Were evidence of corroboration, because the statements of Mr. Apollos and Mr. Van Rijn were not admissible against Ms. Smith, but they were admissible against themselves. There's evidence on record, and if it corroborates his state's evidence, that implicates Ms. Smith. It can only strengthen the state's case on that evidence. And that was the reason why I refused it, because there was evidence before the court on which a reasonable court could convict. So the following findings are made insofar as the witnesses are concerned. None of the evidence was disputed. They then became proven facts. Insofar as Mr. Coetzee is concerned, I accept his evidence for the reasons I've given, having regard to the cautionary rule as well. Insofar as Ms. Lombard is concerned, I find sufficient corroboration for the reliability of Ms. Lombard from other evidence and the circumstantial evidence. And that is the discussion of the planning for turning Joshlin into a commodity and selling it. It's a matter of fact that she went missing. She indicated that all three, the now accused, were party to this pact with her. She's confirmed in that regard by Mr. Apollos and Mr. Van Rijn. They support her evidence in that regard. Over and above that evidence, now read with Mr. Coetzee's evidence, we've got all the other pieces of the circumstantial evidence at play. And most of them, viewed at independently and individually, might not seem significant. Because when one evaluates circumstantial evidence, you look at the evidence in totality. And it is so that all these small little pieces on the Swanepoel's example will complete the puzzle. It might also be seen as the little tiles in a mosaic from which you draw inferences. But as discussed in our cases, reported cases, like the ball of feathers that becomes like a millstone around the neck of somebody, it weighs you down. So let's look at the circumstantial evidence. 2018, Joshlin is a baby. Andrews wants to adopt. Build up a relationship between the two families. Parents does not want to agree. Fast forward to the 18th of February the next year. The 18th of February 2024, Mr. Apollos says he was told by Ms. Smith the reason for selling Joshlin was because of Ms. Andrews doesn't want to stop trying to adopt Joshlin. Circumstantial evidence in that regard, so that little vague triangle becomes brighter. Turning to Ms. Andrews, Ms. Andrews describes the conduct of Ms. Smith because she knows her. And she tells us how Ms. Smith behaved herself after Joshlin's disappearance. Whilst we're there, let's deal with her conduct. She's inconsistent as to why Joshlin didn't go to school that day. The timeline doesn't make sense. She comes home at 5 or 4:45. On the one version, she was aware that Joshlin was not at home at lunchtime. And why not go look for the child? Then you do. But you find it more appropriate to go and charge your phone instead of looking for the child. Then you tell everybody the child made you famous. Then you go jive and dance on the 3rd of March. And there are many more. This is not the conduct of somebody that's unaware of what happened to the child. They go and sleep that night. I want to say stepfather and mother. Next evening you sleep like a baby at Kelly Seeger's house. And so it goes on. Similarly, Mr. Apollos, Joshlin was left in his care. Also, inconsistent versions. Hiding Mr. Van Rijn away, not mentioning Mr. Van Rijn being there, does not partake in the search. He's been told by Ms. Smith, stop the tram, show some emotion. It's uncontested. Why is it necessary? So what I have is that the conduct of particularly Mr. Apollos and Ms. Smith is not that of a concerned parent. And why not? To my mind, the only inference is because you knew. And that supports in itself Ms. Lombard and coming from Mr. Apollos as well. It's not the end of the case. Because all of that was before the court that I've just summarized. At the end of the with all three the persons. They chose to remain silent. You have a right to remain silent. As the Constitutional Court pointed out in State versus Busak, it's not absolute. There comes a time where the evidence is such that it calls out for an answer. And yes, you may still exercise your right, but it has risks, because the court can draw an inference. And the inference I draw is, why not come and answer? You've heard the evidence. Why not come and tell me they're lying? But your conduct was such from day one, not of the trial, from the 19th of February last year. There's no real interest. You don't go and search. You don't do it. Common sense asks us to do. So let's turn to the whether on these facts I can make a factual finding of what happened to Joshlin. Was she delivered to the white polo? Was she delivered to Makalima's house? As from Mr. Apollos and Mr. Van Rijn. Because of the different versions that Miss Lombard gave, I cannot find a warrant of reliability for the white polo. So that's not proof beyond a reasonable doubt on that score, because of the cautionary rule. But is it necessary to find how the means, how Joshlin was delivered? I've already made a finding as to how the law should be interpreted by saying that it's not necessary, but it can be inferred, because you have the plan, you have the purpose, commodify, handover, and it's a matter of fact. Does that satisfy the requirements of the charge? So, on the main count, I have already found that on the evidence before me, Joshlin was exchanged. The fact is that her freedom of movement and liberty was inhibited. Now that in itself are the main elements, the act of kidnapping. Kidnapping is mentioned as one of the means in subsection G of section 4.1, but also the evidence is from all scores. There were payments, or at least the promise of payments. Also, if one looks at the overriding subsection J of the Act, it refers to the purpose that it include all forms of slavery or practices similar to slavery. And the definition section of the Act defines slavery as reducing a person by any means to a state of submitting to the control of another person, as if that person, that other person, were the owner of that person. So by treating a human being, in this case a child, as a commodity that can be sold, it falls within that definition. I've already commented by looking at what the Act is for kidnapping, when I determined whether it falls under the subsection 441 contravention. Clearly that act of depriving Joshlin of freedom of movement and liberty, to the extent that the whereabouts is still unknown, is unlawful. So that will satisfy the elements of the offence on count 2. Now, before I make a pronouncement, I also have to deal with the indemnity of Ms. Lombard. I have decided not to deal with that application or my determination of it now. They will clearly be clear from what I've said so far that there will be another stage in this case. And one doesn't know what more evidence might be presented at that stage that might influence that decision. Furthermore, in the event that I have doubt on that question after all the evidence in the case has been laid, I might consider wanting to grant Ms. Lombard's legal representative to address me on the issue before final determination is made. But the primary reason is that I foresee a possibility that evidence might still be laid in the next phase of this case that might impact that decision. So for the reasons that I have stated, I'm of the view that the state succeeded in proving the guilt of Mr. Apollos, Mr. Van Rijn, Ms. Smith on the main count in count 1 and on count 2. So the following order is issued. You may remain seated. On count 1, you are guilty of a contravention of section 4.1 of the Act, read with the other legislation, on trafficking in persons in relation to Joshlin Smith. On count 2, you are also convicted of kidnapping in the case. Can I just ask the public, please just bear with us. I know that's emotional, and I understand the expression of your emotions. Let us complete our process that we need to do for now. Then I'm going to adjourn. Then you can express your emotions as you wish. There you go. 60 minutes. Certainly. Mr. Policy must listen.
On the 27th of October 2020, is a conviction of theft committed on the 22nd of August 2020. The sentence imposed was a fine of 10,000 rand, or 10 months imprisonment, which was very suspended for 3 years on condition not again convicted of theft or attempted theft. And there was also a declaration that he is unfit to possess a firearm. That is the only conviction against accused number 1.
Mr. Pollis, do you admit the previous conviction? Good. You will be given the form to sign. And I'm not sure whether, do you have a fingerprint pad here? You can do the fingerprint later, warrant officer. Just leave it there, so leave it by yourself.
On the 3rd of October 2014, convicted of 2 counts of robbery, which was committed on the 17th of March 2014. The 2 counts were taken together for purposes of sentence and 24 months imprisonment, which was wholly suspended for a period of 3 years, on condition that it was not again convicted of robbery or attempted robbery being committed within that period. And there was 12 months correctional supervision imposed, and he was also declared unfit to possess a firearm. The next conviction is on the 17th of January 2016, also for robbery, committed on the 23rd of October 2016, and there he was, the sentence was 2 years imprisonment. And then
Mr. Van Rijn, do you admit your previous conclusions? Thank you. Right. So whilst the administrative tasks have been performed by the constable, we now need to plan. So I'll tell you what my prima facie view is. We should maybe postpone the matter to a holding date, which will be a date, say, not this coming week, the week thereafter in Cape Town. I will deal with it early in the morning. And by that date, we will then determine whether you're going to lead evidence in aggravation. I suspect so. Whether the defense wants to call any witnesses in mitigation. Then we'll know how many witnesses we need to call. I hope nobody's going to ask me for correctional supervision report because it's not applicable. No, I'm talking about to the defense already. I'm talking about correctional supervision, but we also don't know whether there are any other assessments to be done. So once we know that, we will have an idea how long it will take to compile everything, but also how long we will need for the sentencing proceedings. And then I would want to come back here, because I think it's as fair that we do it here. But all the prep work we can do whilst being Cape Town, it will also give me the opportunity to, I thought I might still have to go to the office in town today. I was supposed to be in Cape Town today, in the office. But I'll see what I can arrange. So that's just my idea. How do you feel about that from the state side?
That sounds good. The state doesn't need to need some evidence, at least we can impact statements, or definitely be prepared. If the defense, if I might just ask, if the defense could perhaps indicate that they want to...
I'll hear now. Mr. Harmsen. Will you be able to, next week Friday, will you be able to advise me by next week Friday? In other words, I can postpone the matter till Friday next week, which is the 9th of May. I doubt that I have appeals, but we will have a courtroom available, so I can do it in one of the courtrooms there. That's just for everybody to report back. This is what we want to do, so that we can start planning from there. And then we can say we do it at 9 o'clock. All right. Ms. Nkabai. Yeah. Mr. Sivnarayan, similar? Okay. All right. So what I'm going to do is, it's 10 to 1. Right. I'm going to clearly they must be transported to Paul's one. It's going to be difficult now if I issue the order now for Paulsmoor. So I'm inclined to do 2 warrants, 2 detention warrants. To authorize both places, and as I say, at this place and or that place, so that maybe tonight they can be held closer so that they don't have to take the R27 on a Friday in the middle of a long weekend. Otherwise, the police will only reach Paulsmoor when tonight. And they're going to hit the peak hour traffic on their way to Kai. So I'll hear from warrant if I say Malmesbury, and then during the course of the week they can make arrangements for them to be transferred. Okay. And will it be Langebaan for Ms. Smith for tonight? That'll just it'll just make it easier, because I can foresee problems if it's too late. Also, we're not sure what time they're going to leave from here now to wherever they need to go, because there's a lot of admin to be done. I'm also aware that because we made the arrangements the other day, that their parents might be here. I'm not going to make an order. It's not my place. But often what I do is, if I convict somebody, and if it's possible, I tell the court orderlies, if it's within your powers, I won't have a problem if you at least have their family speak to them before you take them away. Right? But I'm not going to make an order because I don't know what the arrangements are. So the following is going to happen. Mr. Van Rijn, Mr. Apollos, I'm going to do your warrant dual, so it will be Malmesbury, Paulsmoor. Ms. Smith, I'm going to do you Langebaan, Paulsmoor. You will be appearing at the High Court in Cape Town on Friday. All that will happen there is I will be informed how we're going to do the process further. And it will depend on availability of witnesses, reports, and so on. And once I have that, if we determine a date, we can postpone the matter back here for a day or 2. It won't take longer than 3 days, I take it, to come and finalize the matter, where I will then have to impose sentence. I want you to give your legal representatives instructions as to what you want to do, because remember, there is a prescribed sentence of life imprisonment on count 1. Just remember that, so that you don't sit back and it's your choice, but so that I have everything before me, and I know the state is going to argue for life imprisonment. So, just give your instructions. Members of the public, can you just remain calm now? I'm going to adjourn. Then give the police an opportunity to take Mr. Apollos van Rijn and Ms. Smith out of the courtroom to the holding area. And then you can quietly leave, or if you then want to clap and ululate or whatever, that's your business. Right? I'm not going to stop you, but let's give them the opportunity to do their work. And then we leave orderly. Remember, we're a big number of people in this hall. Let's leave orderly and thank you for coming. The court letter.